starting to record. I'm starting to record this. So at any rate, if you take a look at the purchase agreement, I highlighted all the areas where there's a way to get out of the purchase agreement. So the first area is right here, right after the purchase price. If the buyer is not willing or able to proceed to the agreed upon purchase, and one, either party makes this agreement or parties may mutually agree to amend upon price, and this is concerning the appraisal. So if the appraisal comes in low, and if the buyer's not willing to proceed at that agreed upon sale price, then they can get out of the purchase agreement, or they can continue forward out right there for the buyer with the appraisal. Then the next one comes here following earnest money, the earnest money section. If buyer fails to timely submit earnest money to escrow agent as agreed to above, buyer agrees seller may terminate this agreement by serving notice of termination to buyer prior to escrow agent's receipt of the earnest money. So it's basically in the seller's hand in this particular case. If the buyer fails to produce that earnest money, the seller can cancel, and it's not a mutual release. It's a notice of cancellation, and there's a form for the in zip forms, and you send that over, cancel the purchase agreement, and the buyer's out. It does not require any agreement, so it's not a mutual release. Then method of payment is another area. So if there are cash, if buyer fails to timely submit proof of funds, buyer agrees seller may terminate this agreement by serving a notice of termination prior to receiving proof of funds. So again, seller can get out without a mutual release if the proof of funds isn't supplied in a timely fashion. So that's another area where the seller can get out without any mutual release in that particular case. Okay, then down here, time for obtaining financing approval. No more than X number of days after acceptance of this agreement shall be allowed to obtain loan approval. And if it's not obtained, then this agreement may terminate unless an extension of time for this purpose is mutually agreed to in writing. So this particular section in here, so whatever you put in there, you need to put a reasonable day to talk to your lender and make sure the lender can meet whatever that time frame is, because if they don't, then the agreement may terminate. Doesn't say that it has to terminate, okay, but it may. So in that case, it would probably be through a mutual release. I don't think it's a unilateral thing. Now, closing. If you don't meet the closing date, then the agreement shall terminate unless there's an extension of time mutually agreed to in writing. Now, a lot of times, we have this whichever is later clause in here. And Jay's position on that is that doesn't change this up here, that the agreement may terminate because of financing approval. So, the situation being most of the time that extends a closing is what? Financing. And so you need to get an amendment for a financing delay that is agreed to by both parties. Otherwise, you don't have a contract, and the seller could sell to another party. And so it's not a good situation to be in. The guy that was teaching this, it wasn't Jay Rose that was teaching, it was another guy, but he's a former commissioner with IAR, and he's the one that brought this up, and he personally had a situation where he had a buyer, and they extended the closing, and everybody was in agreement with it, but they didn't They didn't sign an amendment to extend. The next thing he knows, the house goes back on the market. They find another buyer and pinned it, and he's out. And he has to explain to his buyer that because he didn't get an amendment to extend the closing date, that they have now sold to someone else because they didn't meet this criteria right here, and the agreement shall terminate. So
what did they have in the afterline?
Pardon?
What did they have in the afterline in that situation? Like within X days after what?
Yeah, I don't know what he had in there. But again, you've got and this is why this whichever is later is an issue, because you've also got up here an approval thing.
Yeah, but the approval is subject to interpretation, whichever later is more clear.
Yeah, I don't think you want to rely on that.
Yeah,
I
mean,
I think what you want to do is get an amendment.
Yeah, and the only reason for that is that there's no mortgage disclosure that says mortgage approval. That document doesn't exist, so you can't really time that out or as to when mortgage approval is.
Right.
So that's a problematic with that approval.
This whole section is problematic, and the question is, okay, do you want to go to court over that? So beware. I think you want to get an amendment always to be careful, to be safe. Don't rely on this, whatever is later, and what you wrote in here.
Yeah, or you can make your approval days up there very gracious and generous.
Exactly. Yeah.
I've seen
whichever, and do make sure you are very generous.
I've countered that whichever is later out before.
Huh?
I've countered that whichever is later out before, just so there's a hard date and then that's it.
Yeah, and I've seen that, which is fair if the seller has, financial burden if the closing is later. I understand that, and that's something that's worth doing.
Yeah, it's just something to be aware of. Okay, because of this language right here. And then down here on contingency, obviously it's contingent on something. So if something doesn't happen with this contingency, then obviously the agreement can be canceled. Possession, that's another area where there can be a problem. Now there is a cause for liquidated damages here. But it doesn't mean that the seller or the buyer could, either just, this is a section where there could be an issue. Casualty loss down here, loss by damage or destruction. At buyer's option, they may either terminate the agreement with prompt return of earnest money. So this even specifies they get their earnest money back to buyer, or they can elect to close the transaction in which event seller's right to sell real property insurance proceeds resulting from such damage or destruction shall be assigned in writing by seller to buyer. So that's if a tree falls on a house prior to closing, or something of that sort. The house burns down.
Do you feel somebody could use a mover hitting a wall and dinging up the drywall? Use that clause to get out of it based on that?
Well, it says risk of loss by damage or destruction. I think it would be hard to make it stand up in a court of law that a ding in the wall is destruction of the property. I think they're talking more about significant damage, tree falling on a house
something that enacts the deductible of an insurance.
Yeah,
right, because it's in the casualty loss section. I get it.
Then down here under survey, the survey shall be received prior to closing and certified as of a certain date to be reasonably satisfactory to the buyer. So it has to be reasonably satisfactory. Now, what is reasonable? I don't know. That's something for the court to determine. But the survey is an important part of the purchase agreement and provides an area where someone could get out of a purchase agreement. Same thing with the flood area. If they check that they may terminate this agreement if the property requires flood insurance, obviously, in that case, if it requires flood insurance, they could get out of the agreement. So always when you're doing a listing, always check to make sure it's not in a floodplain, then you don't have to worry about that. Building use limitations, again, they could get out of a purchase agreement if they can't use the building the way they intend to. So if they're purchasing the property for a rental or income property, and then the neighborhood restrictions prohibit that, then obviously they could get out of the purchase agreement. Then homeowners insurance. Completion of this transaction shall be contingent upon the buyer's ability to obtain a favorable written commitment on homeowners insurance with X number of days after acceptance of this agreement. And I've heard in the past that sometimes if a property has had mold in the past, and there's been a claim for that, that it can be difficult. Some insurance companies won't take that property for insurance. So you want to make sure that your buyer gets their insurance right away. I always tell them that after they get a purchase agreement, I tell them the first two things you need to do is, one, order your inspection, and two, order your insurance, your homeowner's insurance. That way they've got plenty of time to find out if there's any problem insuring this property. So that's another area where somebody could get out.
Is that a mutual release on that one, or a
What?
termination? Is that one, if they can't get the insurance, is it mutual release or or can they just submit a termination?
You know, it doesn't say, it doesn't give any guidance. It said completely, it's a contingency.
Right.
So I would say, you know, based on the contingency, it need to be a mutual release. So in mutual release, everything's negotiable, including earnest money. Seller response to inspection defect. Again, we've kind of been through this before, but if seller is unable or unwilling to remedy defects of the buyer's reasonable satisfaction before closing or another time that's agreed to, then buyer may terminate this agreement, or they can waive the defect. So it is within the realm that the buyer may terminate the agreement. Also down here, here's what I was talking about before. Previously disclosed defect, buyer agrees that any property defects previously disclosed by seller or routine maintenance and minor repair items mentioned in any report shall not be a basis for termination of this agreement. So if you do a good job disclosing your defects, then a buyer that goes in and has their home inspection and wants to back out because of a defect that you already disclosed to them, the purchase agreement doesn't allow them to do that.
What
So-
happens if you submit an inspection response and then the seller does not respond within the timeline, but the buyer wants to back out?
Well, first of all, if they don't respond within the timeline, then they've accepted the response.
Right. And it's what they're accepting, what they've implied accepted is ridiculous, but we need to be able to release from this to offer on a new property. So I don't know what to do in that situation.
Well, the time's of the essence. So if you agree that you accept it by not responding, then you accept it.
Right. Well, I have the buyers in this situation. They want to terminate. So we were hoping they wouldn't accept it, so then we could terminate, but they didn't respond at all. So they've implied that they've accepted it.
Yeah, they've accepted it then.
Yeah. So now they have to do all the 28 repairs that we've asked
Well,
for.
you could still ask for a mutual release and point out to them, now you've accepted all these repairs, because they probably don't realize that's what they've done.
Yeah.
So you could ask for a mutual release and say, we want the earnest money. And because otherwise you're going to have to do all these repairs. And they're going to be much more likely to play ball with you that way.
Yeah. Okay.
But at any rate, Now, were any of the defects that you want repaired previously disclosed?
No, it was open door, so they didn't know anything.
Oh, yeah, okay. Absolutely. So nothing was disclosed. This is why failure to disclose is a big deal. You just leave yourself open to lawsuits, you leave yourself open to problems, you leave yourself open to cancel purchase agreements. If you disclose things, then people know up front what they're getting into. And number two, then they can't terminate because of those things. So if you've disclosed that there's a foundation issue, then they can't later on, after they've submitted a purchase offer, say, I want out because it's got foundation issues. They could say, I want out for some other issue, but not that because you disclosed it. So important to disclose. Okay, then down here, title approval. Seller must convey title free and clear of any encumbrances and title defects, with the exception of any mortgage assumed by buyer, and any restrictions or easements of record not materially interfering with buyer's intended use of the property. So if something comes up that would not make this statement true, then that would be a basis for getting out of the purchase agreement, because that's a contingency. So any contingencies obviously can get you out. Down here under time is of the essence, seller and buyer have the right to withdraw any offer, counteroffer prior to written acceptance and delivery of such offer, counteroffer. So you can cancel it before you even get an accepted purchase agreement if you do it prior to getting the signatures. Homeowners association, of course, we all know about homeowners associations. And so if it's in a community governed by a mandatory homeowners association, then the following must be provided to the seller or to the buyer by the seller. Okay, so by the seller to the buyer. So the buyer is not responsible to go out and get the covenants and restrictions. You as a list agent are responsible to supply that to the buyer within this time frame that's indicated on the purchase agreement. If that's not done, they could back out of the purchase agreement. Down here, buyer needs to make a response down here within a certain number of days. If in the event the buyer does not accept the previous provisions and the documents and such provisions cannot be waived, this agreement shall be terminated by the buyer and earnest money deposit shall be refunded to the buyer promptly. So a case might be, for instance, if someone wants to build a fence, and so they get the covenants and restrictions, they find out a fence can't be built on that property, and so now they want out of the deal. They can get out of the deal with return of their earnest money. So another place where they can get out of the deal. And then I think this is there's two other places. One here, expiration is offer. If the offer is not accepted within the time frame, then the purchase agreement is null and void. So there is no purchase agreement. For instance, you can't, if you miss the expiration of an offer, you can't counter back changing the expiration time. Okay, after it's expired. It's expired. The purchase agreement is null and void. There's no way to counter it. There's no way to amend it. It doesn't exist. So you have to write a new purchase agreement. If the seller meant to accept the buyer's purchase agreement, then you need to write a new one with a new deadline. And then finally down here, you can always reject an offer, in which case the purchase agreement doesn't exist either once it's rejected. So those are the things that I learned in the Gay Rose's CE training. The other thing I want to talk to you about while we still have some time here. First of all, update on Brokers Listing Cooperative. If you go to your My Board Central homepage and you click here for technology updates, it brings up this familiar page of technology updates. It's called ConnectBLC Open Feedback and Issue Resolution Status. If you scroll down the bottom of this thing, it has not been updated for 10 days. 10 days. During this time period, I've submitted numerous tickets for various things. Not a single one has been responded to. So I don't know what's going on down at my board. I don't know why they're doing this, but I don't know if they're not working on anything or what's going on with ConnectBLC. But
I just got a response yesterday from them saying that they have resolved an issue that I've put a ticket in for twice in the past like month or 2 months,
yeah,
and it's still not resolved.
it's still not resolved. I
No.
got the same thing maybe a week ago. I got one like that where it was resolved and I said, no, it's not resolved. I replied back,
Yep.
never heard from them.
Yeah.
So these BLC issues are continuing, and the fact that this is not being updated bothers me a lot, because it tells you that they're not conscious of what's going on out here with among the agents. Show you some of the issues, and maybe you guys are having the same issues. The software just doesn't work. For instance, this section right here, you're supposed to be able to scroll down and see all your activity. It doesn't scroll. It only shows you as much as this little box will show you. Now, sometime back when we first implemented this software, you could scroll down through this. So something's changed and this section no longer works.
What happens if you click the top right button there to the left of it? The one that's clicked is like the boxes. Does click that and then does it let you scroll?
Nope. It shows me more. You can see that there's more there,
Yeah.
but it only shows me that same amount within that box.
Yeah.
Okay, so either way I go, I only get that box. That's all I can see. I can't scroll within it or anything. And so I don't know what they've done, but that no longer works. It just simply doesn't function anymore. The other thing is I was going in here, I've been trying to get, so I'm going to settings in here, and I've been trying to get where I can be able to send myself the agent,
Like a report.
agent report instead of the consumer report. Well, I went in and I thought, well, maybe there's a default I need to check or something. So went in here and I checked all these defaults. Well, I went on prospecting defaults, and it shows me that I can determine what my prospect gets. Default detailed client report. Okay, so I set it all to legacy agent full. But when it emails out, it's still just the full detail report. So this doesn't work. The only place where this works is if you're looking on a search. I can change the default that comes up there, but the email, this doesn't work. But this says this is what you email to them. So it says your clients will be able to view listings you email to them in brief one-line summary and detailed reports. Select the default detailed report to display to your clients. Note, you can override the default detailed report you select here when you email listings or create new prospecting searches. Okay, so you have this here. I have found nowhere where you can override this, but it doesn't matter because I've selected legacy agent full, and it's still just emailing the consumer full report. That's the only report that it will email. So I don't know if this is something that is still in works that they've added and they haven't completed the other side of it yet, or what this is. But it's rather frustrating when you go through this process and you find that it it just doesn't work. It doesn't let you change the things that you might work. Now, in here, search and report defaults, this is supposed to change the report that you get as an agent. It doesn't. However, it does it does change your default report in the search. So if I go in and search for a property, I've changed mine to legacy agent full. So if I go in here and search for a property, let me just pull up a property, any property here. Yeah, I'll pull this one up. Oh, it didn't do it. Interesting. Maybe I have to go to search. This is interesting. Sale active, Hamilton County. Okay, so I'm looking at active properties in Hamilton County. In my search, I go in and click on one of the properties, and now it shows me the legacy agent view. But it's interesting, it only works that way on a search. It doesn't work that way on a from the search bar. So if I look up a property from the search bar, I just get the full agent. But if I do a search, I get the agent legacy report. So it's very inconsistent the way it works. My recommendation to everyone is continue to submit tickets even though they seem to get ignored. Go in here and check this on a daily basis. I've submitted a couple of tickets already because this hasn't been updated. And so whenever I go in here, I go to the bottom and there's a little helpful or not. I always check that. It's not helpful if it's 10 days since it was updated. It's worthless to us. So if you get a chance to bring it to somebody's attention, please do. Otherwise, this is not going to get fixed. They're not going to switch back to Matrix, so that's not going to happen. So you also have a survey coming up. Please respond to that survey. Let Myborn know what you think. That's it for today. We're out of time. So actually overtime. So I'm going to stop my recording here.